Hold on, let me get back to the, there we go.
Great. We are recording, everybody. Thanks so much for joining us today on this beautiful, what is it, Thursday morning. I'm Michael Minson, and I wanted to kick off this investor series today. We're really going to talk about exciting content around impacts on California's new tenant protection laws. We've assembled an amazing panel of experts in real estate and law to really walk you through and explain the nuances, some of the pitfalls, and some of the things that you need to know as either an investor or a real estate professional. Can you advance for me, Isaac? I don't have control. Thanks. So our goals today are pretty simple, but we're going to go deep. So we really want to understand the new law and the new landlord and tenant law called the California Tenant Protection Act. And we're going to explore some of the impacts and the opportunities this creates for investors and landlords in the Bay Area and all throughout California. And then we'll have plenty of time for questions towards the end. So if you have any questions, we do have a packed room today. So if you do have any questions, if you could type them in the Q&A section at the bottom of the screen, we'll be able to divvy those up with the right person and keep the conversation moving. So we also are recording this. So we will post this at levelupgroupsf.com/rent control. That page exists today, but there's of course no video on it. At the end of the day, probably within 24 hours, we'll have the content posted there. So without further ado, let me introduce our panelists here today. I'm Michael Minson. I'm the owner of the Level Up Group at Keller Williams Realty, also the operating principal. Andreas, do you want to introduce yourself?
Hi, everybody. Thanks for joining us today. My name is Andreas Ernst. I'm working closely with Michael and Isaac. I have been and I am working with a lot of investors and have been involved with a lot of landlord-tenant issues. Looking forward to sharing some of the insights with you today.
Awesome. And then last but not least, Isaac Jacobson. Would you like to say hello?
Sure. Hi, everyone. Isaac Jacobson. I'm an attorney. I'm the principal of Jacobson Law PC. I represent landlords and property owners, and I specialize in representing landlords in rent and eviction controlled cities like San Francisco, Oakland, and Berkeley, and now, as we'll discuss, the rest of the state.
So just a quick check, can everybody see the screen and the cameras? Send me a note in the chat box if you can. Make sure that we're not talking to people who can't see us. Great, thanks Jared. All right, Isaac, do you want to kick us off with, tell us about the TPA?
Sure. Okay. So what this is about is the Tenant Protection Act, which is AB 1482. We've heard about it for a little while. It was initially passed by the legislature in September, signed into law in October by Governor Minson. Takes effect January 1st, 2020, and applies to all of California. So it creates statewide rent and eviction protections. A hallmark of any rent control law is that it has these two sides to it. One is rent control, and that typically we see as limiting the landlord's right to raise the rent. The ordinance or the law will provide a limitation, a percentage, usually based on CPI, making it so that a landlord cannot raise the rent more than a certain amount every year. But then we also have this other side to rent control, which is the eviction protections. Any well-conceived rent control law will have these eviction protections as well. As you can imagine, if there were no eviction protections, landlords would evict tenants the minute they fell below the market rent and then move in new tenants at the market rent, skirting the rent control law. So you have to have both of these to make a rent control law work. And the Tenant Protection Act has actually been codified under the Civil Code. The rent control section of it is 1946.2, and the eviction protections are 1947.12. So if you're looking for these online, or if you want to cite them, those are going to be how it's been codified. And we're going to start by talking about the rent control side. So basically what this does is it establishes a limit of 10% or 5% plus inflation, whichever is lower, for your yearly rent increase if you have a covered unit. The unit is covered by rent control if it was built 15 or more years ago and is not otherwise exempt. So new construction, you don't have to worry about right now, although years from now, this might cover new construction because it's a rolling 15-year date. So we're going to start by looking at these exemptions because they're very important. Now, there are a number of exemptions, but I went through and chose the ones that I thought would be most applicable to the people that are watching and listening today. The first is a single-family home and condo exemption. It's actually, the way that it's worded in the law are separately alienable properties. These are properties that can be sold separate from any other property. So if you're looking at an apartment building, different apartments in that building cannot be sold separately. They're not separately alienable. But a single-family home or a condo, they are separately alienable. If you had a 3-unit condo building, you can sell one of the units separate from the other units. So those are separately alienable properties, and there's a little star here next to it because there's a caveat that we're going to talk about in a moment. But before we do, there's a few other of these exemptions that I want to go over. The second here is duplexes in which the owner occupies one of the units at the commencement of and throughout the tenancy. So important note here is that a tenant that lives in one of these units is not going to lose rent control once a landlord moves into another unit. So a good example would be if you have a duplex and both of the units are being rented by tenants. One of the tenants moves out and the landlord moves in to that empty unit. The remaining tenant actually still has rent control because the landlord was not living in that duplex at the commencement of the tenancy. Now, if that remaining tenant vacates and a new tenant should move in, now that unit where that new tenant is living will not be rent controlled because the landlord is living in the other unit at the commencement of that tenancy. So that's an important note. There are other ones here, Section 8 BMR, which is below market rate, and affordable housing. Those are generally going to be exempt. There's some nuance to that, but we're not really going to get into it too much. And then finally, units covered by a local ordinance permitting a lower rent increase. Generally, if you own property in a city that has a rent control law right now, that rent control law is probably going to trump the state law. For instance, San Francisco, the allowable rent increase is 60% of CPI. It's usually about between 1% and 3%. It rarely gets up to 3%. And so that's going to be way lower than 5% plus CPI or 10%, whichever is lower. That's the way the state law is. So you're looking at, if you have a unit that's presently covered by San Francisco's ordinance or Oakland or Berkeley, or any of the major ordinances, that ordinance is going to apply, and the state law is not. Okay. We talked about this caveat with respect to these separately alienable properties, okay? That caveat is that these single-family homes and condos are exempt from rent control as long as they don't have a corporate owner, they're not owned by an LLC with a corporate owner, and they're not a real estate investment trust. And the owner gives the tenant a notice. So that right now, if the tenancy predates July 1st, 2020, that notice isn't going to be part of the lease. It doesn't have to be part of the lease, but it still has to be disclosed in writing to the tenant. And if it is a tenancy beginning after July 1st, 2020, it has to be a notice that's in the lease. So here's the notice.
So Isaac, before you jump in there, that's a big deal. There's even an arrow that says this is a big deal. Can you go back real quick? So what happens if they don't have that text? What if they comply, they're not a corporation, it is a single family home, it is a condo, they're not an LLC, but what if they don't give them this notice before July 1st next year?
Yeah, so it's a required notice to get the exemption. So if you don't give the notice, or if you start a tenancy after July 1st and don't have it in the lease, that unit is going to be covered by rent control, where it would otherwise not have rent control. So it's very, very important. And in fact, my advice is, right away, you should updating your leases. If you have a single family home or a condo, something that would be exempt if it had this notice, you should be updating your lease right now with this required language. And if you have any units that are single family homes, condos right now, that could be exempt if you send this notice out, you should send it today. You should not wait. There's really no reason to, and it would be a big problem for you if your unit that would otherwise not be rent controlled would be if you just failed to send this notice.
Hey Isaac, before we jump off of this, it's such an important topic. We really think people are going to get hung up on this a lot. Does it apply to tenants on month to month? Meaning they're not in an active an annual lease.
Yeah, it does. So the tenant is on a month to month. You still got to give them this notice if they're going to continue to be living there, and as we will find out, they are actually going to have the right to continue to occupy the place, unless they're given this notice. Jumping ahead a little bit, but yeah, month to month, you would want to give this notice or put it in their lease going forward.
And last question on this, even though San Francisco is exempt, or single families and condos are exempt in San Francisco, would this state law overlay that? And if we don't provide this disclosure to the tenants, they could claim rent control, the state law?
Yes. Yes, it's an additional requirement that the state requires of single-family homes and condos now in order to achieve that rent control exemption. So make sure that if you have a single-family home or a condo, that you put this into your lease right away.
Great.
Okay. So that is a basic overview of the rent control section. And we're going to get into the other part, which we discussed, the eviction protections, which work in tandem with the rent control ordinance, or the rent control law. And the eviction protections limit a landlord's right to evict a tenant. And they apply only if the building was built more than 15 years ago. So it's the same new construction exemption that we're looking at with rent control. The building is not exempt. So there's a number of exemptions here. And the tenants have occupied the unit long enough. So all three of those have to be met to have these eviction protections. Starting with the tenants having occupied the unit long enough, basically the eviction protections apply if a tenant has lived there continuously for 12 months. If a new tenant moves in, we have to, and now there's, the original tenant plus another one that has moved in. We have to look at a second section here, which says that the eviction protections apply if all adult tenants have continuously and lawfully resided in the unit for 12 or more months, or at least one of the adult tenants in the unit has continuously and lawfully resided in the unit for 24 months. Okay, so if, for example, you had a tenant move in and then about 5 months later, you had another tenant join that tenant, you'd be waiting until all adult tenants have continuously and lawfully resided in the unit for 12 or more months before the eviction protections applied there. If you had a tenant living there and about 15 months later, another tenant were to move in, you would, the eviction protections would apply once that original tenant had been there for 24 months. So it's whichever is the lower amount of time there. So we're going to talk then about the exemptions again. There are a number of them, but we're going to focus on the ones that are probably affecting the people that are watching this and listening here today. We have the same single-family home condo exemption, the separately alienable properties, and it requires the same notice. Let me see if I can go back here. Here we go. You'll see in the notice that it applies to section 1946.2 and 1947.12. So long as you serve this notice or put it in your lease as we've instructed, then you'll be in compliance and exempt from both the rent control side and the eviction control side, as long as you're a single family home or condo not owned by a corporation, an LLC that is owned by a corporation, or a real estate investment trust. Okay. We also have an exemption for units covered by a local eviction protection ordinance. Again, there's some nuance here, but for the purposes of this presentation, if you have a unit that's covered by San Francisco's ordinance, Oakland's, Berkeley's, I believe Richmond's, any of the main ones that are well conceived, those units will have the local ordinance govern. They'll be exempt from the state one. So we also have the same duplex exemption that we talked about a moment ago as well. And we got a few more here. So another exemption are units where one tenant lives with a landlord and shares a bathroom or kitchen with the landlord. So this would be someone who is renting out a room in their house or in their condo. It would also apply to master tenants subleasing a room in their apartment. So those units would be exempt from eviction protections. And we have single-family owner-occupied residences, including a residence in which owner-occupant rents or leases no more than 2 units or bedrooms / accessory dwelling units. So we see this a lot. This is your typical sunset property where there's a little additional unit attached and they're renting that out. The landlord is living upstairs. That property is going to be exempt, even if the landlord is also renting out a bedroom or something like that. Pretty common scenarios, and those were specifically exempted here.
And I think that's different than the San Francisco ordinance, though, where San Francisco considers an in-law, whether it's legal or not, to be rent controllable. Is that correct?
Right. So as soon as you've got a separate unit in San Francisco, now you've got a multi-unit building. It would be eviction protected regardless, depending on the year that it was built. But it would also be rent controlled in San Francisco because it's just considered a separate unit, and it doesn't lose the eviction protections or the rent control. Now, if a landlord in San Francisco lives in the same unit as his or her tenant, then the eviction protections generally do not apply. But a separate unit, even if it's illegal, that exemption goes away in San Francisco. Not under the state law, though. Under the state law, the tenant would not be evicted protected, even if they're in a separate, accessory dwelling unit from the landlord.
Great. Thanks for clarifying.
Yeah, of course. Okay, so this is really the bread and butter of the eviction protections. It's a just cause for evictions. And that means that in order to terminate a tenancy, landlord needs to prove a just cause. And they're enumerated in the ordinance, or in the state law, there are 11 at-fault causes and 4 no-fault causes. Now, You can all kind of guess what an at-fault cause is. That's where the tenant has done something that is maybe, that's wrong, or that we would want to evict them for. By far, the most common type of at-fault cause is failing to pay rent, right? That's very common. You would be able to serve a 3-day notice to pay rent or quit, and that would be in compliance with the state law. We also have breaches of the lease terms, maintaining, committing, or permitting a nuisance, committing waste, which is like damaging the property, criminal activity on the property, and specifically criminal activity or criminal threats directed at the owner or the manager. Those are just causes for eviction. Assigning and subletting in violation of a lease, refusing access to the owner. And one interesting one is the failure of a tenant to deliver possession after the tenant has given notice to move out. So that's always been the state law, that if a tenant gives notice and then fails to move out, you can evict them. But it's not the law in San Francisco or Oakland. There isn't a just cause for eviction just because a tenant has given notice and then decided that they want to stay. So this one actually goes a step further than the San Francisco ordinance and would permit an eviction under that situation. And then there's another interesting one here that is also part of the San Francisco ordinance, which is failing to sign a lease with similar terms at the expiration of the lease. So you've got a year lease, is about to come to an end. You tell your tenant that I want you to sign another lease that's pretty much the same as the first one for another year. And the tenant says, no, I'd rather have this go into a month-to-month, something to that effect. That's a just cause for eviction. They have to sign that lease, so long as they're similar terms. You can't throw in a crazy new term, but if it's the same or similar, they have to sign it. Before we go into the no-fault causes, I want to talk about one important note here, which is that the end of the lease term is not a just cause for eviction. People are probably going to have a lot of questions about this at the end of this presentation. If you're not familiar with San Francisco's or Oakland's or Berkeley's or any of these ordinances, just because you've had a year lease, right, and the year has come to an end, that doesn't cause the tenant's tenancy to terminate. In fact, it will just automatically roll over to a month-to-month and continue indefinitely, unless you've told the tenant they need to sign a new year lease, or there is a just cause for eviction. And the end of the term is not a just cause. So just keep that in mind. If you are planning to rent a unit to a tenant and that unit is going to be covered by the just cause section here, that tenant will be permitted to live there indefinitely unless there's a just cause for eviction, okay? And it seems counterintuitive, but that's really the way that the law is set up. And so we've got those at-fault evictions. This is where the tenant has done something wrong. But the state law builds in these no-fault evictions, okay? And this is where a tenant has done nothing wrong, but we need to allow a landlord to terminate a tenancy for a specific purpose or specific reason. And I'll go into them in a second, but we should also note that when endeavoring to recover possession on a no-fault eviction, a landlord will need to pay relocation assistance to the tenant, either by waiving 1 month's rent or paying 1 month worth of rent to the tenant. And that is only applicable to no-fault evictions. At-fault evictions, there's no relocation payments, obviously. Okay, there are 4 no-fault just causes. The first is owner relative move-in. This is, it kind of is similar to what we know in San Francisco. There's owner relative move-ins in San Francisco's ordinance, Oakland's ordinance, all the major ones. But it's very different. Here, The owner or relative can move in only where the original lease or a new lease allows for an owner or relative to move in, and the eviction must be done by an owner or the owner's spouse, domestic partner, children, grandchildren, parents, or grandparents. And the original lease or new lease must reserve the right to move in an owner or the owner's spouse or domestic partner, children, grandchildren, parents, and grandparents. So what that means is the lease actually has to provide for this reservation. So that's another very important point. I think we're going to point it out in a minute as well, but I'll say it now. You know, if you have a property that would be desirable for either yourself or your family members, or if you were to sell the property to someone who might want to live there or have a family member live there, you should add this provision to your lease right away. The provision should state that the owner reserves the right to move in an owner or the owner's spouse, domestic partner, children, grandchildren, parents, or grandparents. That's all. And it should be in all of the leases, especially for those desirable properties, so single family homes, condos that might have been protected by the eviction protection ordinance, or for maybe a duplex where an owner might want to live there. You gotta make sure that you have that in your leases. And we're going to talk.
Question on this?
Oh, yeah.
What happens if a landlord doesn't specify that?
Yeah, they're not going to be able to do an owner or relative move-in eviction. They'd have to wait out that tenancy and then you make sure that the next time that they have it in there. Or you can sign a new lease with a tenant that includes that, so long as the tenant agrees and signs it. Okay, so the next one we have, and we'll talk about it a bit again in a moment, is the withdrawal of the unit from the rental market. That's all it says. It's not super clear how that applies or how you would comply with that, but withdrawing the unit from the rental market. The next one, the city or county agency requires a unit to be vacated due to an uninhabitable condition. That's usually going to be a notice of violation, something like that. You hear from the city that the property's run down, there's some problem, it's not safe. You have a notice of violation. You'll be able to evict the tenants. You have to pay them relocation, serve them a valid notice, but then you'd be able to correct that notice of violation. And then you've got intent to demolish or substantially remodel the unit. Substantially remodel means the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit, or the abatement of hazardous material, including lead, mold, or asbestos, that cannot be reasonably accomplished in a safe manner with the tenant in the unit, and that requires the tenant to vacate for more than 30 days. It's not applicable for just cosmetic improvements. It has to meet one of these substantial remodel defined improvements. Okay. So again, the state law allows for less restrictions for OMI evictions in San Francisco, Oakland, or Berkeley, but does have this extra requirement that you have disclose or reserve this right in your lease. Now, they are way less restrictive than San Francisco or Oakland's or Berkeley's. In San Francisco, for instance, if you intend to do an owner move-in eviction, at the time that you serve the notice as an owner, you have to presently intend to occupy that unit for at least 3 years. And you have to move in within 3 months of the tenant vacating. You have restrictions on re-renting the unit. You have reporting requirements. You have to report to the rent board for 5 years. Who's occupying that property? It should be you if you've done the owner move-in eviction, or it should be a relative if you've done a relative move-in eviction. But there's those reporting requirements. There's all of that. There's none of that in the state law. The state law doesn't specify how long a landlord has to live there. Doesn't specify when the landlord should take possession. There's no reporting requirements. There's nothing like that, but it does require this disclosure in the lease.
Isaac, quick question. Would you mind to unmute Michael?
Oh, what happened here?
Awesome. Sorry about that. I was coughing and I went to mute myself, but then I couldn't unmute myself.
Oh, okay.
So a couple questions have come in, Isaac. This is very different than San Francisco, and then the tolerance level seems to be far less strict in the California law than what we're seeing in the state law. A couple questions that came in. Is there a percentage requirement for the ownership to do an OMI, to do an owner or a relative move-in?
No, it's not specified. It defines the owner. Let me see if I can pull it up here because I have the definition. Can you guys see my screen right now?
No. We only see the PowerPoint.
Okay. So owner is defined as including any person acting as principal or through an agent having the right to offer residential real property for rent, and includes a predecessor in interest to the owner, except that this term does not include the owner or operator of a mobile home park or the owner of a mobile home or his or her agent. So no percentage there. It doesn't say anything about that.
Great. And when you take the unit off the market, that's pretty vague. I think they're not specifically speaking about the Ellis Act, which is very specific. But this state law allows you to get out of the rental business. But it doesn't. I didn't see anything specifically about how long that duration is. What if you change your mind? Is there a compliance step?
Right.
It seems ripe for abuse.
That brings me to this slide here, the area of contest and confusion. The no fault evictions are very unclear and they're very vague. So speaking specifically to that one, if I can go back here. Withdrawal of the unit from the rental market. Yeah, a lot of people that are familiar with San Francisco's ordinance or the rent control ordinances generally will know about the Ellis Act. And the Ellis Act permits a landlord to basically go out of business, take units completely off the rental market. And in order to do that, and it basically it's like a nuclear option if you want to evict in a rent-controlled, eviction-controlled jurisdiction. But if you want to do that, there's a ton of restrictions. There's a number of notices and recordings that need to be filed and recorded on the property. There are restrictions on re-renting. The process can take up to a year, just a notice requirement process. There's relocation money. There's all of these things that just aren't mentioned here with respect to withdrawing their unit from the rental market. Which, and this state law doesn't mention Ellis Act or the codified version of it. It doesn't make any reference to it. So we would be guessing to say that withdrawing of the unit from the rental market means an Ellis Act eviction. It doesn't say that the unit has to be withdrawn for any specific amount of time. It doesn't have a restriction on re-renting. Now, does that mean that we should infer that there are no restrictions on re-renting or that there's no amount of time that a landlord has to keep the unit off the rental market? I think the answer is probably no. I would not recommend that people make that inference. What I think we'll find is that this provision here, this just cause for eviction, will be litigated. It will be litigated, and we will find out from some decisions in the appellate court that what this means, or we'll see this law be modified in some way to be a little bit more explicit about what it means. The same goes for the owner relative move-in just cause. I don't think that people should infer that the owner can just move in and then immediately move out just because the law doesn't say that he cannot do that. there is no guidance on what the owner should do. And I think that what we'll see again is probably some litigation that clarifies this, and also maybe changes in the law down the line. What I can say is that San Francisco's ordinance, has gone through a lot of revisions, and it didn't look like it does now when it was passed, right, in 1979. So it took them a while to hammer out some of these nuances, and I expect the same for the state law.
Isaac, Sean had a question. What about tenants whose annual lease is coming up and they get a 30-day notice to vacate prior to their 12 months or whatever the term of their lease is? Are you still able to do that, to rent out to somebody else?
No. So that's what I mentioned. The end of a lease term is not a just cause for eviction. So just because you've got a year lease with somebody and it's coming to the end, and you would like to maybe rent to somebody else, or you just want to stop renting to people, that is not a just cause for eviction. In fact, they're entitled to continue to occupy and rent the property, assuming it's covered by the eviction protection law, unless you have a just cause for eviction. So you maybe a no fault or an at fault eviction that's permitted by the ordinance or the state law.
And similarly, Lalo's got a question, Isaac, that's the same vein, but what if you ask them to sign a year lease at the end of that term and they say no? Is that a just cause?
That is. So that's a just cause for eviction. If you get the end of say a 1-year lease, and you as a landlord want to require that the tenant sign another year lease, and that lease has similar terms to the one that you've already had them sign, you can require it. If they refuse to sign it, they only want to do a month-to-month, they want to keep their options open, you can terminate their tenancy. It's a just cause.
That's very interesting. I think, Sean, that would probably be a tactic if that was in consideration.
Yeah, I mean, they could sign it, and then you'd have a tenant for another year.
Right.
And a lot in these, I guess it doesn't say for sure under the state law, but generally, so a lease is a contract, and so when you do a no fault eviction, you can't generally break the contract. And in San Francisco, you have to wait until the end of a term of years lease, until it's moved month to month, to issue a no fault eviction notice and terminate under a no fault eviction. And I believe the same would be true under the state law. So, once you've entered into a year-long lease, you're limiting your options there.
We kind of got into we went really deep in the weeds there. It's an important topic. Anything else, Isaac, to recap before we move on to Andreas, where we could compare the two, San Francisco and California, and maybe talk about some implications?
Yeah, I just had a couple more things on this slide that I wanted to mention, actually. And that is, first of all, another thing that I think is confusing and is an area for contest are that there are no penalties for noncompliance other than rendering the notice void. So that means, you serve a notice, eviction notice, and it doesn't prove a just cause or state a just cause, or you don't have a just cause for eviction. Serve a notice, it's invalid. You would not be able to prevail if you subsequently sued for unlawful detainer and tried to evict them. So there's that. But what if you caused a tenant to vacate by serving them a notice that did not state a just cause, and then tenant just vacated? In San Francisco, that would be a wrongful eviction. We actually have built into the ordinance, it provides that endeavoring to recover possession without proving one of these just causes is a wrongful eviction, and there are actually penalties for that. The tenant is entitled to if they can prove this in a lawsuit, they're entitled to actual damages, they're entitled to their attorney's fees, they're entitled to triple the actual damages, emotional distress damages, and potentially triple emotional distress damages. And that's a significant penalty, but that is not, there's nothing like that that's stated in the state law. Now, that doesn't mean that there are no penalties. And in talking with tenant attorneys, I know that they have plans to sue people landlords for violating this law and for causing people to vacate without proving a just cause. And there are other causes of action that you can use. Unfair business practices is one, which is basically breaking the law for business advantage. Things like that. So they're not immune from repercussions for failing to comply with this ordinance, but it's just very unclear. And I think that the law will change. And then finally, there's no statewide rent board. We in San Francisco, people in Oakland and Berkeley, they know that if you issue a notice increasing the rent, for instance, and that notice doesn't comply with the law, the tenant might go to the rent board and get a determination of that fact. The rent board will issue an order saying, this rent increase is invalid or something to that effect. There's nothing like that for the state law. And so, if you issue an invalid rent increase notice or something like that, the only way that's going to be determined is if you go to court. Like if you issued a 3-day notice to pay rent or quit because the tenant didn't pay that increased rent increase notice, and then you find out through the legal process that notice was invalid or something. So there's just not that shortcut that the rent board provides in determining these rent increase notices and making decisions on evictions and things like that. So that those are all things I think might change or that we should just keep our eyes on as the years progress and as people litigate and deal with this new law.
Great. Sweet. Thanks, Isaac. We got about 18 minutes to go. So if you're okay, I'd like to move on and tee up Andreas, who's going to give us kind of more of an overview of how this really impacts us and how to think about it differently from San Francisco to California.
Great. Micah, thanks a lot. And Isaac, thanks a lot for painting the picture. So for the last 30 or 40 minutes, we have heard a lot about the kind of California state law. One of the key questions that a lot of clients have raised and colleagues as well, how does the state law tie into San Francisco, and how does this tie into the San Francisco rent ordinance? And the chart that you see in front of you is a kind of simplified answer that really breaks it down. So at a high level, the San Francisco rent ordinance covers any properties that were built or their certificate of occupancy was issued before June 13th, 1979. So for just to recap, and most of you probably have heard of this already, multi-units in San Francisco that were built before 79 have rent control and eviction protection. Single-family homes and condos that were built before 79 have eviction protection. So that's simplified. So now the state came in, the state of California, and pretty much extended that up to 2004. As Isaac mentioned, there's exemptions for properties that were built within the last 15 years. But what that means for San Francisco is that now the rent control and eviction protection is extended until 2004. So from 79 until 2004, unless you are exempt. What we learned from Isaac is, as a single family home and as a condo, if you file the proper notification, you are exempt. However, the buildings that are not exempt are multifamily units, specifically the ones that were built after 79 and before 2004. And then 2004 and beyond, there's no rent control and eviction protection. Next slide, please. And this is just kind of a slightly deeper level of what we just talked about. I think the two pieces I like to highlight, which Isaac alluded to earlier in the presentation, is that the rent increases in San Francisco, as well as the relocation payments and processes, are significantly stricter than at the state level. So for example, the allowable rent increase in San Francisco is 60% of CPI, which is basically very minimal. Historically, it's been between 1% and 3%, versus at the state level, it's a 5% plus CPI or 10%, whichever is less, which is actually quite quite generous, relatively speaking, to San Francisco. Same with relocation kind of payments and the process, right? In San Francisco, there are very specific rules when you can, what you can and cannot do, and how much you need to pay per tenant, versus at the state level, it's a lot more generous and lenient at this point. What I would like to do is kind of give you two specific examples just to make it a little more tangible.
Before we jump forward, Sean had a question about how much can you raise a rent after from a tenant after their lease expires. And so the answer, if it's in San Francisco, you've got 60% of CPI, which has been about 1 to 3%. Or if it's California, it's 5% plus CPI or 10%, whichever is lower. And do we know what CPI is about right now?
I think it's about.
I forgot to look it up before this.
It's a federal number. It's about 1.8 according to Google.
But what this is measured on is based on a local CPI. So you can look that up. That ordinance actually provides where exactly you'd find that. And yeah, there will be one for the Bay Area. 3%
for the year over year. So that would be 5 plus 3. So allowable rent increase would be 8% according to what I just looked up on Google. Okay. And so that's pretty generous raise, pretty generous increase. That doesn't seem too punitive for the landlord.
No.
And so the key conclusion here is there's a big difference if you are covered by the San Francisco rent ordinance, right, which has a lot of limitations. And if you're covered by the California kind of ordinance, there's a lot more leniency there when it comes to rent increases as well as owner moves in and regulations in general. And any more questions? This is great. I think this is highly relevant for a lot of people here on this webinar.
Not right now. Thanks, Andreas.
Great. And so just two specific examples. So this is actually a property that Mike and I sold earlier this year. It's a condo, very typical. It was built before 79. There has been, this falls under the San Francisco rent ordinance, right? It's a condo, which means there is no rent control, but there is eviction protection. And the new California state law would not have an impact on this building. And that's really the vast majority of buildings in San Francisco. Moving on to the next example. So here, on the other hand, this is another listing of kind of the level up team, Michael and myself. This is a building that was built in 1986, which means before the state law, it did not fall under the San Francisco rent ordinance, which means there's no rent control and no eviction protection. Having said that, and given what we just learned from Isaac, now with the state law, there will be, or now there is, California rent control and California eviction protection on the building. So this is an example of a building that is affected by this change. Yeah, we just wanted to share like two tangible examples so you can see what that really means in San Francisco. And then last but not least, if we move to the next slide, is kind of really impact in San Francisco and what the best way to think about it is. So generally speaking, because in San Francisco there already is a very stringent rent control in place, we believe that the impact in San Francisco overall is fairly limited. It's really limited to kind of the yellow field you saw of multi-unit buildings that were built in 1970 and 2004. As Isaac shared earlier, single-family homes and condos are exempt, but here it is really important that landlords file and provide the appropriate exemption notices. It's going to be very interesting to see what happens if a lot of landlords don't, and what percentage of tenants might take advantage of that, if you will. And finally, there's a big open question on what does this new statewide rent ordinance do to California as an investment? Is it going to make it more interesting, as the state of California as investment less interesting? Is it going to have no impact? So I think that's something that remains to be seen. The idea behind the 15-year exclusion really was to provide enough incentives for developers to continue and build new inventory, which is really at a shortage in the state of California, but it remains to be seen if that actually happens. Any more questions on how this ties into San Francisco and if there are any potential overlaps?
Not yet, but I think this next one I'll take, which related to the proposed, there's a new, the team and I, we spent a lot of time discussing, should we even bring this up? Because it's not a real thing yet, but we thought it was relevant to this group, especially that for you to know that supervisors Haney, Fewer, and Ronan, they are in the process of introducing new legislation with the Board of Supervisors that would basically remove that June 1979 limitation and basically eliminate the benefit or the exemptions for new construction with no cap on it, with no date. So this would basically apply rent control to all of the new construction within San Francisco. And it does introduce a conflict with Costa-Hawkins. So we're not really sure what's going to happen here. We wanted more than anything to put it on your radar and for you to be an informed consumer and an informed voter. Do some research on this. It hasn't come to the Board of Supervisors yet, but we understand that it's working its way through the committees and so far has received support from 3 of the supervisors. So stay tuned on that one. That one is definitely a big deal. All of these are a big deal. Andreas and Isaac and I work really closely together on any of our clients that have a investment need to purchase or need to sell, or just questions about what to do with my property. And I've got questions about how to handle tenancy and rent control and evictions, and how does this apply to my home or my investments. Please consider us a resource. We're here to answer these questions for you. This is what we do. Our contact information is right here. And it's been a real pleasure to present this to you. Again, we will save this on our website, levelupgroupsf.com/rent control, and we'll make it available to you within 24 hours. We don't have any more questions. We're about to wrap up here. Make sure everything's cleared. Thanks, Sam. Thanks, everybody, for joining.